Undoubtedly, a person may be a citizen, that is, a member of the community who form the sovereignty, although he exercises no share of the political power and is incapacitated from holding particular office. Women and minors who form a part of the political family cannot vote, and when a property qualification is required to vote or hold a particular office, those who have not the necessary qualification cannot vote or hold the office, yet they are citizens. So, too, a person may be entitled to vote by the law of the state who is not a citizen even of the state itself. And in some of the states of the Union, foreigners not naturalized are allowed to vote. And the state may give the right to free Negroes and mulattoes, but that does not make them citizens of the state, and still less of the United States. And the provision in the Constitution giving privileges and immunities in other states does not apply to them. Neither does it apply to a person who, being the citizen of a state, migrates to another state. For then he becomes subject to the laws of the state in which he lives, and he is no longer a citizen of the state from which he removed. And the state in which he resides may then, unquestionably, determine his status or condition, and place him among the class of persons who are not recognized as citizens, but belong to an inferior and subject race, and may deny him the privileges and immunities enjoyed by its citizens. But so far as mere rights of persons are concerned, the provision in question is confined to citizens of a state who are temporarily in another state without taking up their residence there. It gives them no political rights in the state, as to voting, or holding office, or in any other respect. For a citizen of one state has no right to participate in the government of another. But if he ranks as a citizen in the state to which he belongs within the meaning of the Constitution of the United States, then, whenever he goes into another state, the Constitution clothes him as to the rights of person, with all the privileges and immunities which belong to citizens of the state. And if persons of the African race are citizens of a state and of the United States, they would be entitled to all these privileges and immunities in every state, and the state could not restrict them, for they would hold these privileges and immunities under the paramount authority of the federal government, and its courts would be bound to maintain and enforce them, the Constitution and laws of the state, to the contrary notwithstanding. And if the states could limit or restrict them, or place the party in an inferior grade, this clause of the Constitution would be unmeaning, and could have no operation, and would give no rights to the citizen when in another state. He would have none but what the state itself chose to allow him. This is evidently not the construction or meaning of the clause in question. It guarantees rights to the citizen, and the state cannot withhold them. And these rights are of a character and will lead to consequences which make it absolutely certain that the African race were not included under the name of citizens of a state, and were not in the contemplation of the framers of the Constitution, when these privileges and immunities were provided for the protection of the citizen in other states. The case of Legrand versus Darnall, 2 Peters, 664, has been referred to for the purpose of showing that this court has decided that the descendant of a slave may sue as a citizen in a court of the United States, but the case itself shows that the question did not arise, and could not have arisen in the case. It appears from the report that Darnall was born in Maryland, and was the son of a white man by one of his slaves, and his father executed certain instruments to manumit him, and devised to him some landed property in the state. This property Darnall afterwards sold to Legrand, the appellant, who gave his notes for the purchase money. But becoming afterwards apprehensive that the appellee had not been emancipated according to the laws of Maryland, he refused to pay the notes until he could be better satisfied as to Darnall's right to convey. Darnall, in the meantime, had taken up his residence in Pennsylvania, and brought suit on the notes, and recovered judgment in the Circuit Court for the District of Maryland. The whole proceeding, as appears by the report, was an amicable one, Legrand being perfectly willing to pay the money if he could obtain a title, and Darnall not wishing him to pay unless he could make him a good one. In point of fact, the whole proceeding was under the direction of the counsel, who argued the case for the appellee, who was the mutual friend of the parties, and confided in by both of them, and whose only object was to have the rights of both parties established by judicial decision, in the most speedy and least expensive manner. Legrand, therefore, raised no objection to the jurisdiction of the court in the suit at law, because he was himself anxious to obtain the judgment of the court upon his title. Consequently, there was nothing in the record before the court to show that Darnell, who was of African descent, and the usual judgment and award of execution was entered. And Legrand thereupon filed his bill on the equity side of the circuit court, stating that Darnall was born a slave, and had not been legally emancipated, and could not therefore take the land devised to him, nor make Legrand a good title, and praying an injunction to restrain Darnall from proceeding to execution on the judgment, which was granted. Darnall answered, averring in his answer that he was a free man, and capable of conveying a good title. Testimony was taken on this point, and at the hearing the circuit court was of opinion that Darnall was a free man, and his title good, and dissolved the injunction, and dismissed the bill, and that decree was affirmed here, upon the appeal of Legrand. Now, it is difficult to imagine how any question about the citizenship of Darnall, or his right to sue in that character, can be supposed to have arisen, or been decided in that case. The fact that he was of African descent was first brought before the court upon the bill in equity. The suit at law had then passed into judgment and award of execution, and the circuit court, as a court of law, had no longer any authority over it. It was a valid and legal judgment, which the court that rendered it had not the power to reverse or set aside. And unless it had jurisdiction, as a court of equity, to restrain him from using its process, as a court of law, Darnall, if he thought proper, would have been at liberty to proceed on his judgment, and compel the payment of the money, although the allegations in the bill were true, and he was incapable of making a title. No other court could have enjoined him, for certainly no state equity court could interfere in that way with the judgment of a circuit court of the United States. But the circuit court as a court of equity certainly had equity jurisdiction over its own judgment as a court of law, without regard to the character of the parties, and had not only the right, but it was its duty, no matter who were the parties in the judgment, to prevent them from proceeding to enforce it by execution, if the court was satisfied that the money was not justly and equitably due. The ability of Darnall to convey did not depend upon his citizenship, but upon his title to freedom. And if he was free, he could hold and convey property by the laws of Maryland, although he was not a citizen. But if he was by law still a slave, he could not. It was therefore the duty of the court, sitting as a court of equity, in the latter case, to prevent him from using its process, as a court of common law, to compel the payment of the purchase money, when it was evident that the purchaser must lose the land. But if he was free, and could make a title, it was equally the duty of the court not to suffer Legrand to keep the land, and refuse the payment of the money, upon the ground that Darnall was incapable of suing or being sued as a citizen in a court of the United States. The character or citizenship of the parties had no connection with the question of jurisdiction, and the matter in dispute had no relation to the citizenship of Darnall. Nor is such a question alluded to in the opinion of the court. Besides, we are by no means prepared to say that there are not many cases, civil as well as criminal, in which a circuit court of the United States may exercise jurisdiction, although one of the African race is a party. That broad question is not before the court. The question with which we are now dealing is whether a person of the African race can be a citizen of the United States, and become thereby entitled to a special privilege, by virtue of his title to that character, and which, under the Constitution, no one but a citizen can claim. It is manifest that the case of Legrand and Darnall has no bearing on that question, and can have no application to the case now before the court. This case, however, strikingly illustrates the consequences that would follow the construction of the Constitution, which would give the power contended for to a state. It would in effect give it also to an individual. For if the father of young Darnall had manumitted him in his lifetime, and sent him to reside in a state which recognized him as a citizen, he might have visited and sojourned in Maryland when he pleased, and as long as he pleased, as a citizen of the United States, and the state officers and tribunals would be compelled, by the paramount authority of the Constitution, to receive him and treat him as one of its citizens, exempt from the laws and police of the state in relation to a person of that description, and allow him to enjoy all the rights and privileges of citizenship without respect to the laws of Maryland, although such laws were deemed by it absolutely essential to its own safety.